All right, who appears to be appellant, please?
May it please the court, counsel's name is Taylor, and I appear for the appellant in this matter with my learned junior, Ms. Bond.
Thank you. For the respondent?
May it please the court, counsel's name is Ms. Hyde, and I appear for the respondent, my junior counsel, Daji.
Right, thank you. All right, would you like to start, Mr. Taylor?
Olivia Mackay will be 2 years old in November this year, and she is a much-loved and integrated and vital part of the Mackay family. The case this court has to decide today is whether or not Mercy Gully Hospital should pay for raising her and her maintenance costs through to the age of 16. The lower courts have said they should, but we say today they should not. And we put before this court that this appeal today must be upheld. There are two main issues. I will argue the first, which is that Mr. and Mrs. Mackay cannot recover the cost of raising and maintaining Olivia under the tort of negligence due to a failed sterilisation which has resulted in an unintended pregnancy and birth. My junior, Ms. Bond, will address the court on the second issue and will contend that the release of one tortfeasor should operate to release all other joint tortfeasors from liability. Before beginning with submissions, would your Honours be assisted by a summary of facts?
No, thank you. We've read the papers. We're aware of the facts. Thank you.
Do your Honours require full citations?
No. No. Thank you.
Your Honours, I'll turn to the first issue of contention. Olivia Mackay is a young child, but a vital part of the Mackay family. She may not have been a planned addition to that family, but is certainly not an unwanted addition now she is here. The English House of Lords has held that the cost of her upbringing and maintenance must fall on the family and the parents. A tort of negligence to recover the cost of an unwanted pregnancy due to medical negligence in this jurisdiction does not exist. This is based on the idea that a child must not only be seen as a burden or financial liability, but a benefit, and to say otherwise would have highly detrimental effects on that child going forward to the future. Also, the idea that the hospital or health board has a duty of care to pay for a child in situations like this is not allowed within that jurisdiction. In essence, Your Honours, the court holds that the parents should pay because that is what is just, fair and reasonable, and I will be contending that this court should follow the reasoning from the House of Lords.
But just stop there. The entire purpose of the sterilisation was that the parents, one of the main purposes was that the parents did not want to be financially disadvantaged by another pregnancy, another child. Now, how can it be just and fair if in these circumstances where the sterilisation fails, through no fault of them, that they have to bear that cost?
Your Honours, it would be submitted that the child must not only be looked at as an economic loss, but a benefit to the family unit in itself, and that when we weigh those two up, that the benefit should outweigh the cost. Further to that, it was a decision of the Mackay family to keep and integrate Olivia into their family life, which carries a duty and an obligation by law, which they chose.
You're suggesting that they should have mitigated their losses by having the child adopted out?
Your Honours, that is certainly an option before the family. However, if the court is not swayed by the limited damages rule, which is my first argument from the House of Lords, we argue that there is a break in the chain of causation.
Can I just stop you there? The limited damages in the first stage doesn't factor in this alleged benefit of having the child. How do you say that plays through to the second stage then?
Your Honours, the limited damages theory takes into consideration the fact that a child is beneficial to the family in an uncalculable manner, so beneficial that it has to outweigh the cost. Further to the fact that to look at a child as an economic burden, but not actually look at them as a benefit at all, is detrimental to the child and to the idea children in society, and that links into that,
Why specifically? Where's the empirical evidence?
why that child is a benefit, Your Honour.
Or why it's detrimental to award damages?
Your Honour, if I could just turn you to submission 1.3.5. The English decision in McFarlane and the Australian High Court decision in Katanā discussed that what the court doesn't want to put forward to the child is that if they find out about this case, they believe what the court has said, that they are more trouble than they are worth. To find in favour of the fact that the hospital should cover the cost of rearing that child, it seemed that the court has accepted that they are such a burden to that family that somebody else should pay that cost, and that the benefits of that child don't mitigate or overpower that loss in itself.
If we follow your argument through, though, aren't we creating a particular immunity for doctors that ordinarily wouldn't exist for other professionals?
Your Honours, I would argue on that point that it's not creating such an immunity due to the fact that there may still be, if this court finds that perhaps a sum of money is owed to the parents, that perhaps a small conventional sum, as per argument 3 in this first submission, is adequate, because that small conventional sum would go to recognising the legal harm, and that legal harm is that that decision to limit the family has been taken away. However, that would still recognise that the child is a benefit and not just an economic loss.
What is a small conventional sum?
In the case of Rees through the English House of Lords, it was decided in that case that that would be up to £15,000 for that, as that was recognised the fact the legal harm came about. And in the McFarlane case, Lord Millett suggested £5,000 as a starting point.
Certainly small, but why is it conventional?
Notice that was the wording that the judges used, and they used it to show that it wasn't compensatory in its nature, that they weren't trying to put the parents back in a position they were before, which is the purpose of compensatory damages, to put someone in a position they were before, but recognise the fact that a legal harm had happened to those parents.
Thank you. Proceed.
Notice if I could take you back to the first argument, where I will look at the limited damages rule which the House of Lords adopted. Notice, in the case of McFarlane, the judges did a fairly sound analysis of the law in other jurisdictions, and in that it was found that all but 6 states in the United States, the Canadian jurisdiction, the French jurisdiction, and even the New Zealand jurisdiction was more in favour of this limited damages rule, that you could not get costs for covering child rearing costs out of medical negligence. Whereas that particular judgment in McFarlane was unanimous by all 5 judges, and was unanimously affirmed by all 7 judges in the Rees decision, and further 3 judges in the Australian High Court in Katanā. So therefore it submitted that this idea that the majority of jurisdictions is in favour of this limited damages rule was accepted and held by 15 of the 19 judges in the case law before you. And we're submitting today for the appellant that this should be persuasive and this court should find with those jurisdictions. Particularly to note was the New Zealand jurisdiction, and that McFarlane case said that Justice Cook in the case of L&M, which has been affirmed in the case of XY and Accident Compensation Corporation and in Re Z, say that you cannot get the cost back of rearing a child, that there has been an injury possibly to the parent with the birth and the pain and suffering, but it does not extend further than that to the maintenance and raising of the child.
Do you not say that this is consequential loss?
It's conceded that it could be looked at as consequential loss. However, council would say to that point that the benefits that come from the child, Olivia in this particular case, overwhelm and outweigh whatever that consequential loss would be.
Isn't that a matter for Parliament though? I mean, we're here to apply arguably conventional negligence principles. If Parliament wants to legislate to that effect, isn't it up to them?
It would certainly be a matter that Council would put before Parliament. However, it would be argued that if the court was to find against the appellant, that they would be supporting the idea that a child can be viewed as an economic loss or a burden, but not take into factor the benefits that that child will bring. Your Honour, if I could direct you to 1.3 in submission. We argue that the child and the best interest of the child should be the focus of this court.
And where do you get that from? That's a proposition of family law, and we're not sitting in family jurisdiction today.
We would say that that is a consideration that comes across to this particular case today. What we're looking at is in terms of a child, and we say that there is benefit from that child, and if this court was to find in favour of the respondent, that that would have a highly detrimental effect going forward on that child's view in life.
But what about the harm to the parent?
We would say that the parent has suffered a possible economic loss under their obligation and responsibilities as a parent. However, they have also gained incalculable benefits that come from that child-parent relationship, and that can be evidenced on the facts of this case, that there is a loving family. They have accepted Olivia within that family, and that has flowed on to more friendships, more relationships through that connection of Olivia, and we say that that will continue going forward into the future.
It's all very well looking at these particular facts and arguing from them, but if you're asking for a universal rule, you have to factor in that we could have a very different situation with perhaps a woman on her own, heavily mortgaged, decides she couldn't afford a child, has a sterilisation that fails, she becomes pregnant, her whole economic world falls apart. She can't afford the mortgage, she goes on a benefit. So your rule won't allow for people like that. It might allow for these people, but it won't allow for that situation, will it?
In that situation, we would say that a possible exception to the rule could be looked at by the court.
So there's no broad rule then. I thought you were arguing for a broad rule right through these cases.
We would say that you need to establish a broad rule, but then exceptions to that rule, like the case of Rees did. The broad rule was set in McFarlane, but in the case of Rees, it looked at whether there could be an exception to that rule, and again, in other English cases where there was a disabled child, was seen as another exception to this rule to give rise to those particular special circumstances above and beyond an ordinary family, which we're looking at today in this court.
Doesn't that though just create an incentive for parents to manipulate factual circumstances and say, well, my child's disabled or degrees of disability, trying to get away from the broad rule? Don't you think that we're better off with one rule that applies to all rather than trying to carve out exceptions here, there and everywhere?
That would certainly be an argument, Your Honours. However, that particular argument of a disabled child would need to be proved in court based on evidence, in particular expert evidence as to what that level of disability is, and we can see from there what those possible costs are going to be on a more objective scale. We would argue today that if this court was to find that Mercy Valley Hospital had to pay for the raising and maintaining of Olivia, that would give greater incentive for parents to manipulate the situation, that they would then be able to possibly argue that Olivia was going to be so bright she needed to be in private education, that she required a whole range of costs which could possibly not equate to what she's actually going to get in life, and that gives more of an incentive to manipulate the truth due to the fact that there's not that backstop of more objective evidence before a court.
But in one way or other, this kind of consideration attaches to all litigation, doesn't it? You might as well say that people cheat or could cheat in any kind of claim, so why should it make any particular difference to this kind of claim?
It's submitted that the court should be looking at ways to mitigate the possible manipulation, and that in that sense it's more objective, and the English case that did say that a disabled child could get extra costs associated to the health board, not the ordinary costs of raising a child, but extra costs associated due to the disability, that's more factually and concretely proven in a court, and that the court should be allowing for exceptions of this nature, but to find that a parent in every situation can just claim with no concrete evidence to support what those costs would be, because we don't know what we're going to be in the future. We don't know exactly what.
So how do we fix the problem of sloppy doctors then?
In terms of doctors' negligence in terms of their medical care, we would argue that there is already procedures in place through medical boards. Those doctors can be held to account, but it is not the role of the court to put an imposition on them of this nature, and it takes it outside the duty of care that they owe to those patients.
So I'm a bit unclear, why is it outside the duty of care?
It would be submitted that it wouldn't be in the reasonable contemplation of those doctors that if there was a unplanned pregnancy that came about, that they would then have to pay for the entire costs of raising that child. But further to that, Your Honour, the aim of damages in this court is to compensate for reasonable restitution and to allow the entire cost of raising a child and maintaining a child goes against that principle, because although it would put the parents back to where they would be financially, they have had all of this benefit from a relationship with a child to grow into an adult and other friendships that grow out of it, that they are put in a place far advanced on where they would be normally. And we argue that the court should not be doing this. Now, if I could just turn your attention to 1.4.3 in submissions. In terms of legal policy, we would submit that allowing a claim like this could also lead to a floodgates argument on the facts of this case in particular. Your Honour, in this case, the doctor and Mercy Gully Hospital sat down with Mr. and Mrs. McKay and told them that there was a next to zero chance of contraception after the sterilisation. Your Honours, next to zero is not no chance. There is a risk of contraception still, and that if this court was to say, and due to that risk, the McKays then chose to run that risk and to have unprotected intercourse, which resulted in a child knowing full well that there was a chance, however slim, that they could conceive a child. Honest, it would be submitted that there are other birth control measures that can be taken between parties engaging in intercourse, and that those particular birth control measures also have a next to zero chance of contraception from that particular act that the two parties engage in.
I'm locating the evidence where it was found that the statement wasn't a next to zero chance. Can you help me there, please?
That's on the first page of the facts, Your Honour, that the The procedure was a great success and the chance of her becoming pregnant again next to zero. And that's in paragraph 5.
Thank you.
Your Honours, it would be argued from the appellant.
Isn't that a greater reason to make the doctor here liable?
We would respond to that saying, what more could the doctor have done? The doctor talked to Mr. and Mrs. McKay, told them honestly and truthfully of the risk that they still had as a result of the sterilisation, because not all operations are 100% successful. That would create an exceptionally high onus on surgeons and doctors in the medical profession. They told Mr. and Mrs. McKay there was still a chance, and Mr.
Well,
and Mrs.
no. They said it was next to zero. And if an ordinary person were told next to zero, I don't know that they would construe it as a chance that they're going to end up pregnant. It's more likely than not.
We would argue that in cases when you're involved in intercourse and you use a condom or you use birth control pills, there is a next to zero chance in those cases, but people are still aware of the fact that they could still get pregnant and have an unwanted pregnancy. And that if that principle was applied here, Mr. and Mrs. McKay knew there was still a chance they could get pregnant and chose to run that risk anyway.
Okay, thank you, Mr. Taylor. We need to stop you there. Thanks very much indeed for your submissions.
As it pleases the court.
All right. Mr. Long.
According to Justice Tipping, in the Court of
must always receive some sort of value or consideration where a release is obtained. The plaintiff is satisfied in a release and has no further cause for action, whereas a plaintiff may not be satisfied after obtaining a judgment and therefore has the right to pursue a further cause of action.
So are you saying that it all turns in the judgment call on whether the plaintiff in fact receives the remedy that he or she sought? Is that what you're saying?
Can you repeat the question?
Are you saying that the judgment rule proceeds on the basis that it operates only if in fact the plaintiff does not receive the damages that he or she obtained by the judgment?
No, Your Honour, that's with respect not the appellant's submission. The judgment rule proceeds whether the plaintiff received a favourable or non-favourable judgment. The cause of action is able to be shifted to the next joint tortfeasor, and the plaintiff is able to sue them for a judgment as well. Whereas with the release rule, the plaintiff has given up their right to take the second or third joint tortfeasor through to a judgment, because the plaintiff has taken it upon themselves to settle, generally for value or consideration. So they have received that value or consideration, and the issue has been settled, and therefore the appellant submits that they lose their right to then pick up that cause of action and sue the second or third joint tortfeasor.
So you're in the Supreme Court now, and the Supreme Court will be looking to broadly deal with the situation. If the court felt that it had the ability to set the law here, wouldn't it be best for the court to say, well, it depends on the circumstances of a particular case and the intentions of the people involved in every case?
The appellant would submit, Your Honour, that that leaves the law in an unsatisfactory state. As mentioned in one of the cases, it is submitted that the tortfeasor who is released from liability is entitled to some certainty and some finality in that release. And so if the law was left open as to whether that release was going to operate or not, it would be submitted that the tortfeasor's rights would be affected with regards to finality and certainty.
But what about the situation where you may have been able to locate one of your many? You don't know where the others are, yet you may not have ended up completely whole. Shouldn't the contribution issue still be live, rather than everyone being released just because you've entered into a settlement with one person?
The appellant submits, with respect to Your Honour, that no, the issue should not still be live, that tortfeasor should be released from liability because it was at the hands of the plaintiff that released them, whereas the plaintiff was quite within their rights to take that person through to judgment along with any other joint tortfeasors that were around or as may be the case, not able to be found at that time. So
But the whole purpose of settlement is that you avoid the costs of litigation. By simply drawing an arbitrary line between I settle with you and I'm not released, or I go to judgment and I am, it just encourages people to go all the way to litigation, which is not what we really want, is it?
no, Your Honour, the appellant accepts that avoiding litigation is certainly desirable, but it is the plaintiff's right to seek judgment and obtain damages from any number of parties that are involved in the tort of negligence, and if one is not obtained from that first tortfeasor, then it is submitted that the plaintiff should be within their rights to seek remedies, seek damages from the other tortfeasors. Similar to if they were in a release situation, they have had that opportunity to recover part of the damages that they've suffered. Does that answer your question?
Just perhaps continue and we'll come back to it.
Moving to submission 5, Your Honours. Section 17(1)(a) of the Law Reform Act 1936 did not abrogate the release rule. Justice Thomas, in his judgment in Robinson, said would assume that if Parliament did have an issue with the way the release rule was operating in practice, that they would have explicitly addressed it in the statute along with the judgment rule. Support for this view can be found in the judgment of Robinson by Justice Tipping, where he states that if Parliament had intended to abrogate the release rule, they would undoubtedly have directly addressed it. And further support can be found from the judgment of President Cook in the Brooks case, where he said, clearly it is well arguable that a logical corollary of the 1936 would be an abrogation of the release rule. However, there are strong grounds for holding that Parliament did not intend to do so.
And how do you reconcile that submission with the Australian position?
Your Honour, I'm going to address the Australian situation further down at 5.5. Would you like me to take you there now?
Up to you.
I'll continue if that's okay. The single issue for the Court of Appeal in Brooks was the liability of one joint tortfeasor on the release of another. The court was not convinced that such an established rule had been indirectly abrogated by statute and held that the release rule still applies in New Zealand. This issue was also discussed by the Court of Appeal in Robinson. However, as Justice Blanchard stated, that case concerned the consideration of statutory liabilities, so the court was not, it was not necessary for the court to determine the status of the release rule. However, Justice Tipping did say in that case that unless and until changed by statute or expressly departed from by this court in a case where the point directly arises, the decision in Brooks is to be regarded as correctly stating the current New Zealand law. Justice Thomas, on the other hand, explicitly stated that he would adopt the rationale of the High Court of Australia in Thompson and Australian Capital Television, which nullified the release rule. And the appellant submits that this decision should not be followed for reasons which will be discussed at 5.5 grounds. Justice Tipping in Robinson spoke highly of the Court of Appeal in Brooks, praising their exploration of a number of points, which together he said provided a powerful case that Section 17.1 was neither intended to have or has the effect of abrogation of the release rule as well as the judgment rule. One such point in the court in Brooks was the evidence highlighted from McElroy and Breeson's text, the Law Reform Act 1936, which was devoted entirely to this new piece of legislation and drew attention to the fact that voluntary payment or settlement was not included in the reforms. The court also discussed the English Law Reform Act 1935, of which the New Zealand Act is said to have replicated. Neither of those statutes mention the release rule at all. And the English Law Commission noted that they preferred to leave the issue of the release rule for further examination in later law reform. Justice Blanchard in Robinson said that it has very much been the predominant view in the English Law Reform Act that the bar created by the judgment rule was removed, but that the Act had no impact or no effect on the release rule. Your Honours, if I can now direct your attention to the Australian High Court case of Thompson and Australian Capital Television. The court found that the common law rule that a cause of action against joint tortfeasors is one and indivisible was abolished by Section 11.2 of the Law Reform Act 1955. As already submitted, the fact that the cause of action is no longer indivisible does not prevent the release rule from operating in New Zealand. However, the appellant submits that there are also other factors that make Thompson unsuitable for this court to follow.
Just to stop you there, if you say that, or accept that the one and indivisible basis is done away with, what do you say the conceptual basis for the rule is then?
The conceptual basis for the release rule, Your Honour, is the policy considerations around the finality and submit that there is a factual basis for the rule. That is what I've just discussed with you, one of the policy reasons surrounding the finality and the contribution, which I'll touch on further. Section 17(1)(c) of the New Zealand Act and its equivalent in the Australian Act provide that a joint tortfeasor who is found liable for damages may recover a contribution from another joint tortfeasor. So if a claimant settles with tortfeasor A and then sues tortfeasor B, the appellant submits that it is unfair on tortfeasor A that he or she is still liable for contributory negligence, contributory damages, if the judgment is found against the second tortfeasor. Therefore, the interests of justice, as held in the Brooks case, favour the retention of the release rule in order to protect the tortfeasor who has already given value to the complainant and paid for the damage. I can just return your honours to the Australian case of Thompson. I'm now at 551 of my submission. The majority of the Court of Appeal in Robinson thought that the judgment of the Australian High Court provided little analysis beyond saying that the effect of section 11(2) was that the cause of action against tortfeasors is no longer one and indivisible, and that it was doubtful that the Privy Council in the case of Waitat Bank, which the High Court relied on to a considerable extent, was doubtful that the Privy Council was speaking of more than the judgment merger rule, and that the subject of release by means of settlement was simply not mentioned. The Court of Appeal in Brooks came to the same conclusion in that relying on the case of Waitat Bank was not recommended, as the Privy Council simply held that the English legislation abolished the common law rule as to the barring effect of a judgment. In fact, the Court of Appeal in Brooks said that the only express judicial support that exists for the view that the release rule can be treated as discarded is that of Lord Denning in the case of Bryanston Finance. However, his comments were challenged in that same case by Lord Diplock, who expressed the opposite view that the release doctrine was unaffected by the Act. At 5.7, Your Honours, another factor that reinforces the submission that Parliament has not abrogated the release rule is the fact that if it had, there would be necessary restrictions in the Act that correspond to those that restrict the recoverability under the judgment rule. Section 17(1)(b) of the New Zealand Act limits the sums recoverable under the second judgment based on what was recovered under the first judgment. To apply the same approach to the release rule, it would be necessary to lay down corresponding provisions to the effect that the settlement agreed on with one tortfeasor should provide a limit on that agreed for the second tortfeasor. Your Honours, I've already addressed the points at my submission in part 6. So, to conclude the submission for the appellant, the release of one joint tortfeasor should operate to release all other joint tortfeasors from liability, because the release rule and the judgment rule are materially different, and therefore one can conclude that Parliament only intended to abrogate the judgment rule with the enactment of section 17(1)(a). The release rule continues to play an important role in the finality of settlement for the released tortfeasor. To sum up the entire submission for the appellants, Your Honour, I will conclude submission 1. It is an unintended pregnancy and the birth of a child. The parents are not entitled, under the tort of negligence, to recover the costs of raising and maintaining the child due to the limited damages rule
questions? Thank you for submissions. Right, thank you. Now, Ms. Hyde.
Your Honours, we present you today a family who has exercised their right to limit the size of their family, a decision they justified by grounds of financials. Despite taking steps to exercise this right and being told that their steps were successful, the family were then burdened with unwanted financial costs, something they had taken these steps in order to prevent. They now seek to be restored to the position prior to the wrongdoing. Counsel for the respondents have two submissions today. I will address the first issue, which is our submission that where medical negligence results in unintended pregnancy and the birth of a child, the parents are entitled under the tort of negligence to recover the costs of raising and maintaining that child. My learned junior will address our second submission, detailing that the settlement reached between Mr. Davies and the McKays did not act to release Mercy Valley Hospital from liability. I will now turn to submission 1.1, Your Honours. We submit that this is a regular negligence claim, and that therefore the respondents are entitled to claim the damages. This is a situation that involves plain and simple economic loss. As it is a financial situation, we submit that it should be characterised as such, with application of regular negligence principles. The respondents are simply claiming for the expenditure they have incurred and will continue to incur due to the negligent acts of the appellants. And we submit to you this makes the case a regular economic claim. It was acknowledged, Your Honour, in cabinet that cases such as these ought to be viewed realistically and with real-world analysis. When this is done, it can be established that the situation at hand revolves around money. It is not a case about quantifying love, Your Honour, or working to ensure the preservation of the family unit remains. It is simply about money.
If it is about money, you'd have to accept it's very hard to calculate what the money should be, would you?
Your Honour, we accept that while money may be difficult to calculate, we think that this is something that's been agreed upon, will be discussed in the second trial phase. We also believe that it will be possible to come to a conclusion as to the amount that ought to be awarded for the maintenance of a child.
Okay, that's not quite my question though. I'm asking you whether or not, on the yes/no question, whether there should be a right to recover the cost of maintaining the child. The fact that it is extremely difficult to calculate the amount and there are so many discretionary choices there is a consideration on whether or not there should be a recovery or it shouldn't be.
Your Honour, we submit that the discretionary choices should not prevent the respondents from being able to recover the costs.
Why?
We submit that the courts will be able to come to a conclusion as to the amount that ought to be awarded in terms of a ballpark figure for raising a child.
For a part figure, does the child go to private schools or public schools?
Your Honour, we submit that this is something. We submit that this is not something that should come into consideration when determining whether the child the maintenance should be paid out. We submit that the issue at hand is that the parents have suffered financially, and we think that the discretionary differences in such amounts ought not to prevent recovery.
So if we lifted the conventional damages award slightly, would that satisfy you?
That's not what we submit today, Your Honour. The conventional damages would not be sufficient enough to maintain and raise the child.
How do we know it's not a ballpark figure?
The conventional sum offered by the respondents, I believe, was around $15,000, which we submit that it's possible that calculations can be done to the average cost of raising a child in New Zealand. These calculations would not
So you say there should be no deductions from that for any benefit that the child might bring.
So I've addressed that in my submission. I can turn to that now, Your Honour.
Up to you.
So we submit, Your Honour, at 1.5 that the benefits that accompany the birth of a healthy child do not stand in the way of a damages claim, and that they do not serve to negate the harm that has been suffered and the loss that's been incurred. So while we do not deny, Your Honour, that the birth of a healthy child will bring benefits to the parent and to the family into which it is born, we submit that these benefits are subjective and varying and cannot be borne off against the quantifiable injury that has been suffered. Lord Hayne has illustrated that regardless of any blessings that may be bestowed upon a family, it is inherently true that the parents will suffer if it was an unwanted child. He has stated that it is not uncommon to find that the birth of an unwanted child will create a situation where parents may be worse off economically, emotionally, socially. So with this in mind, it is not appropriate to balance the losses suffered with a potential blessing. In response to the idea that a child is always a blessing, it was stated by Justice Kirby that this is a plain misconception and a fiction that ought not to be accepted given the absence of objective evidence. In comparison, however, we submit that there is evidence, as I just touched on, surrounding the truth that a child will not always be a blessing. As Justice Dixon said in Public Trustee, even when one of two separate interests is benefited in consequence of a wrongful act, that benefit cannot be set off against an injury to another. An example he used, and one that was recognised by Justice Kirby and Catnack, was that of a husband who's lost consortium with his wife. Damages for this are not offset simply because he is now no longer under the expense of supporting her. This is a clear recognition, Your Honours, of the principle that regardless of an intangible benefit that may be gained as a result of negligence, in no way is it a matter of requirement that the damages should be reduced or eliminated because of the intangible benefits of parenthood, because we submit that they are substantially different in quality and in kind to the cost that a parent incurs. We submit that the court should not attempt to quantify them, that they should be ignored.
And you say that this lump sum should be paid all in one go, or how do you propose?
Your Honour, I think that's a matter for the courts to decide at a later date. However, if it is going on an average cost of raising a child, then we see no reason why it ought not to be paid as a lump sum.
Or if the child dies in a year?
There's a potential issue, Your Honour, so that if these are things which the courts wish to take into consideration, then it may be more appropriate that the hospital pays out as per the cost as it is incurred. We don't see that should stand in the way of awarding the damages.
So you're saying that the court could make a judgment that required the damages, if you like, to be paid on a monthly or 6 monthly or yearly basis?
That's not something that we are entirely opposed to, Your Honour.
Okay, thank you. Proceed.
So I'll turn back to submission 1.1. Just to reiterate that as in the Catnack case, it was acknowledged that all elements of a regular economic claim were satisfied. And in Catnack, Justice Callahan succinctly summarised the issues, saying that because the expense would not have been incurred had the first appellant not acted negligently, then all of the various touchstones for and none of the relevant disqualifying conditions for a regular award of economic damages were found. So it's important to note in this situation, Your Honours, that the respondents are not claiming for damages in an attempt to punish Mercy Valley Hospital for wrongdoing. As in accordance with the principles of negligence, the claim is merely to restore the respondents to the financial position they would have been in had it not been for the negligent act. So I will now direct Your Honours to submission 1.2, where we discuss that Mercy Valley Hospital is liable for the losses suffered by the Mackays in respect of the duty that was owed. The appellants have at no stage denied responsibility for the failed operation, and to be precise, Mercy Valley Hospital has accepted that they owe a duty of care to avoid unintended pregnancy and childbirth. Lord Hope of Craigie has stated in the McFarlane case that there must be a relationship of proximity, and that in order for liability to be found, the relationship must be just, fair, and reasonable. In the case at hand, Your Honour, we established that the harm was foreseeable, but furthermore that it is justifiable to link the birth of a child and the financial encumbrances that accompany this to a failed sterilisation operation. We submit that this justifiable link makes the claim for maintenance one that is recoverable against the appellants. It was established in the McFarlane case that the board must have foreseen that the negligent advice would give rise to adverse financial consequences, and that therefore should be liable in respect of these consequences. We apply this to the case at hand, Your Honours, for it must be said that in accepting that a duty was owed, Mercy Valley Hospital well foresaw that failing to carry out the operation to success would give rise to the aforementioned financial consequences.
What do you say this particular harm is here?
The harm, Your Honour, is with the financial damages and the financial loss that has been incurred by the respondents.
And what do you say to the proposition that the harm should actually be construed as the ability to stop using contraception, or the dissatisfied view that you can stop using contraception?
Could Your Honour repeat the question?
Well, as we've heard from the appellant, the basic loss that you're trying to compensate for here is the dissatisfaction of the parents that they can no longer cease to use contraception. In fact, they should have taken other means to protect themselves against becoming pregnant. Is that not the harm that we're trying to compensate here?
Your Honour, we submit here that Dr. Davies directly told the appellants that the operation had been successful, which is fair and reasonable, or that the respondents would take the successful operation meant that they were therefore sterilised and would no longer be able to have children. With this in mind, we submit that the harm that has been done is that of the birth and conception and birth of a child, which they can actively take steps to prevent. Your Honour, as Justice Hayne and Catmac pointed out, it is an undeniable fact that a parent is legally bound to maintain their child until the child is legally independent. But for the negligence occurred, McKay's would not be encumbered so. As Lord Hayne pointed out, this is not very different to paying out damages for a wrongful death claim, and ought to be considered in regular negligence principles. We submit, in accordance with the judgments of not only Catmac but also McFarlane and Rees, that no break in the chain of causation has occurred. Lord Millett in the McFarlane case stated that if parents have a choice, it is one that they should never have been called upon to make. But there is no choice if there is no realistic alternative. He refused to acknowledge the proposition that choosing to keep the baby had broken the chain of causation. From the moment of conception, it is determined that circumstances were out of the parents' control. As established in McFarlane, abortion might likely have been illegal, and adoption is simply not a realistic option when the parents already have a fully formed family.
Why isn't it a realistic option?
Your Honour, as has been established by the appellants, this is a loving, caring family, and to have other children see the mother bear a child to full term and then give it up for adoption would cause a significant amount of harm. As we've established,
To who?
Sorry?
Harm to who? To the mother or to the other children?
We believe to the family as a whole. This is a conception that was not wanted, and that was steps were taken to prevent it at the start. So from the moment of conception, this was not a choice. This was a choice rather that the parents opted, took steps to avoid having to make. So it is clear that conception and birth and the restoration of the status quo by either abortion or adoption were the very things that the respondents took steps to prevent. So despite an finding against the respondents in the McFarlane case, Lord Millett himself concluded that regardless of the decision of the parents in each case, the causal connection is still strong, direct and foreseeable. So we apply the same reasoning here, Your Honour. Without the negligence that we have established,
Isn't the fact, though, that the Australian states have legislated away the decision of the High Court there quite a powerful reason for us not to follow the same rule here?
Your Honour, in the Australian case of Catnack, they believed, they believed that it was acceptable for the damages to be awarded, and this was on the basis of simple legal principle.
Yes, but the states subsequently within Australia have legislated that decision away. So that no longer stands as a statutory bar.
That's right, Your Honour.
So isn't the fact that the individual states have legislated the decision away a powerful reason for us not to follow the Australian Catnack decision?
I'll now turn to submission 1.3, Your Honour, and discuss that this is indeed a measure of legal principle, and the public policy that is often being used in the other cases does not provide such justifiable reasoning here against an award of damages.
I'm sorry to interrupt you again, but quite apart from the issue of the other states effectively cancelling Catnack, you'd have to accept that it's a pretty lonely decision by a bare majority.
It has stood on its own, Your Honour, against cases such as Rees and McFarlane. However, we believe that the reasoning and the justification by which they came to the decision in Catnack is a sound one, and we support the view that they have taken that this is an economic loss and ought to be treated as such.
Okay, thank you.
In McFarlane, a number of policy concerns were presented to oppose the recovery of costs. However, in this case, the lordships themselves stated that there was no intention of deciding the case on the grounds of public policy. It was noted, though, in Rees and Darlington that despite the statement, there was an undoubtedly strong moral element in the basis of the decision. And this attention to public policy has been criticised by the judges of Catnack, in particular Justice Kirby, who made it clear that McFarlane illustrates what can go wrong when judges are too tied up in the quicksands of public policy and are led away from basic legal principles. We concede that while policy arguments attempt to invoke what are commonly held societal values, we submit that it is not the place of the court to determine the weight attached to these societal values. Instead, that legal principles should be relied upon as a basis for decision in a court of law. Justice Kirby refuted the concepts of public policy, citing a range of English cases he held to be more appropriate, where the arguments that public policy stood in the way of recovering damages were rejected, and it was held that normal legal principle ought to apply. CES and super clinics was one referred to, and Justice Kirby stated that when he himself participated in this case, he saw no reasons grounded in public policy to deny full recovery of damages. Furthermore, to quash the notion that public policy has a place in this case, Your Honour, as noted in Catnack, the claiming of damages is far less morally abhorrent than the action of the abortion of a child or offering it for adoption within wedlock, as the appellates have suggested. We also make point, as acknowledged in Catnack, that finding out at the moment of conception that you were not wanted is not that harsh of a truth to confront, and it was made clear that there are many harsher truths the child may have to face in his upbringing. We therefore believe that this would not be a detrimental decision to the child should damages be awarded. Lastly, I'll just turn to submission 1.4 to submit that the birth of a healthy baby can be considered a legal harm, Your Honour. An invasion of the legal rights of the parents have occurred. We submit that the parents have a right to have the decision to limit the size of their family respected, and that these rights were invaded by the hospital. Not only have McKays been prevented from living their lives as they planned, but they have also become legally and morally obliged to meet a series of unanticipated and unwanted financial costs. The financial burden can be considered a personal harm, one that has arisen from the birth of the child. Furthermore, comparisons were drawn between the harm that would have occurred had the mother miscarried or carried a stillborn child, and there was no doubt in Lord Millet's mind that in these circumstances a harm would be acknowledged and damages would be awarded, not only for pain and distress, but also for financial encumbrances that were occurred. He went so far as to state there would be no basis for denial of claim in these situations, and with this in mind, the This is a negligence claim, and following regular principles of negligence, when determining such an argument, legal principles ought to be at the forefront. Public policy serves no place here.
Thank you, Ms. Hart.
If Council can be of no further assistance, this concludes the first submission for the respondent.
Thank you. Right, Mr. Daly.
Your Honour, the second submission which counsel for the respondent puts before the court is that the settlement reached between Dr. Davies and the Mackays did not act to release Mercy Valley Hospital from liability. In order for the court to arrive at this conclusion, I make two parallel arguments. I do so to provide alternative routes and finding that Mercy Valley Hospital remains viable. The first proposition I intend to make is that the common law release rule no longer applies in New Zealand. Secondly, and alternatively, I propose that Mercy Valley Hospital is jointly and severally liable for the damage caused to the Mackays. I intend to present these propositions in the order I have stated, unless of course the Honour directs me otherwise. Is there any particular area you want me to begin?
You begin where you'd like to, thanks, Mr. Daly.
Thank you, Your Honour. Your Honour, my first proposition, as previously stated, is that the common law rule, the common law release rule, no longer applies in New Zealand. Again, I offer two parallel arguments in reaching this proposition. As we are concerned with the interpretation of the statute, I would invite the court to firstly consider a literal approach and secondly a purposive approach. My learned friend for the appellants has duly noted that in abrogating the judgment rule under section 17 of the Law Reform Act New Zealand, the legislature did not expressly or impliedly abolish the release rule. However, I note that counsel for the appellant has effectively conceded this argument and admitting that the basis for the release rule lies within policy reasons for finality and certainty. However, of necessity, I will contend this claim.
I don't know that she conceded that the rule didn't apply. I think she just conceded that it was not, the rationale was no longer one and divisible. It was more that the rationale was now policy reasons.
That is correct, Your Honour, and that is precisely what I intend to contend. May I refer you on to the position of Justice Cook. May I refer you on to the case of Thompson in Australian Capital Territory in the Australian jurisdiction, where the judges of the High Court were faced with interpreting the abrogation question in regards to section 11 of the Australian equivalent to the Law Reform Act. The learned judges relied on the approach of the Privy Council in the earlier case of Waitat Bank Limited in Chan, which my learned appellant has already mentioned. They approached the question by asking whether the legislature had succeeded in abolishing in its entirety the common law rule that there was only one indivisible cause of action for a joint tort. They answered the question by stating that it is a canon of construction that a statute should not be construed as altering the common law any further than it does so expressly or by necessary implication. However, it is also a canon of construction that statute should not be construed in such a way as to lead to injustice or absurdity unless its language makes no other course possible. Although section 17 could have been drafted in simpler and more explicit language, their lordships considered that it expresses with reasonable clarity the intention of the legislature to abolish the common law rule in its entirety. I invite this court to follow this reasoning in concluding that section 17 of the Law Reform Act provides reasonable clarity in the intention of that statute.
It's a hard one though, isn't it, really? The statute expressed in what it abrogates, and it obviously doesn't turn its mind to a very simple and expectable other proposition if it wanted to make it, but it didn't make it.
I'll approach John for reasoning. It was precisely the reason for my parallel argument, namely the purpose of approach. When I draw attention to 1.4 of my submissions, it is accepted that Parliament did not expressly address the rule, although it would have been fully aware of it. Justice Thomas noted that statutory reform tends to advance by statutes correcting particular defects in law. He coined the term used by Professor Eaton and describing this process as legislative microsurgery, a process intended to make the law even more of an amalgam of common law and statute. The legislature could have drafted the statute in simpler and more explicit language, but there would have been nothing micro about that.
But this is not legislative microsurgery. The legislator cut off one leg and left the other leg there.
As you said earlier, the Mooting Supreme Court intended to take a broad approach in addressing this issue. The necessity in this rule is that the process of statutory reform must be in response to some defect in law. My learned opponent has illustrated this defect, and I hope to do so by illustrating the words of Justice Thomas and Robinson, who stated that Parliament was concerned with a major problem, that is, the situation where a plaintiff who has sued one tortfeasor to judgment and recovered nothing cannot afterwards proceed against another person who is equally liable. The release rule operated on the same basis. Therefore, the same problem arises. Councillor Paul.
What do you say then to the proposition, though, that if we are to abrogate both of these rules, one's definitely gone, that we've got this gap in relation to the mechanism for contribution that we either have to fix as courts or Parliament has to fix down the track? And it certainly hasn't fixed it in the statute in relation to the release rule, although it may have fixed it in relation to the judgment rule.
Your Honour, my learned counsel for the opponent stated that it will be necessary for similar restrictions to apply for the release rule. However, the problem concerned with Parliament and Parliament's intent was not to provide any type of restrictions to the release rule in particular, because Parliament's intent was not the release rule itself. It was the single and indivisible cause of action. It was a consequence of their intent that the release rule was also abrogated.
So do you say, though, that when Parliament abrogated the judgment rule and put in place a mechanism for contribution, that the intent of Parliament was to abrogate the release rule as well, but put no mechanism there for contribution?
Your Honour, in point 2 of my submissions, if I might just turn there quickly, the court in Thompson and the court in Robinson asked the question as to what basis exists for the continuation of the release rule. I believe it's a similar question to what you're asking about. I would ask the courts to carefully consider Parliament's intention in fixing a major problem at the same time as offering major solutions to the same problem. Again, it may not have been in Parliament's mindset or on the agenda for them to consider the effects of the release rule being abrogated as well.
It just strikes me as odd that if the statutory argument that you put forward is correct, that Parliament would consider the effects of the judgment rule but not consider the effects of the contribution rule.
If I may take on respect to the point I was previously at, I quote the works of a surgeon professor, Professor Williams. He stated that the release rule had been strongly criticised for years by many circumstances as well, necessary restrictions didn't seem to fix the problem either. So Your Honour submitted that it was not on Parliament to provide solutions to a problem which had existed historically, as noted by these jurists. As I was previously stated, Your Honour, Professor Williams, his works were referred to in both the cases of Robinson and Brooks. In the case of Robinson, the court quoted his words in stating that the modern refinements to the release rule had become an encumbrance and a snare. Justice Thomas added that nothing short of unthinking allegiance to an exaggerated perception of the doctrines of precedent and stare decisis can counter this sustained criticism. My learned friend from the appellant suggested that the case of Brooks correctly states the law in New Zealand surrounding the release rule. However, Brooks did not involve any analysis of parliamentary intention and only a brief analysis of the literal approach. Justice Cook illustrated this one-sided approach by admitting that no judgment expresses the view that the release rule no longer survives. Moreover, Justice Cook thought it wise, in a remarkably brief judgment, to rely on words of a dear friend, Professor Williams. But in doing so, Justice Cook made a crucial omission. He quoted Professor Williams' words from a 1951 text, stating that the cause of action is one and indivisible, so that when it goes to one, it goes for all. Nothing short of legislation can get rid of it. No mention was made of the problem the same professor identified 2 years earlier, as mentioned in Robinson. Furthermore, absolutely no consideration was given by the three Court of Appeal judges in Brooks to this problem or the intent of Parliament in fixing it. Perhaps the learned judges were not aware of the problem, which is unlikely given the history of the rule, or perhaps the court simply chose to divert from the path set out by Parliament, thereby neglecting to conduct a comprehensive analysis of the legislature's intent. Whatever the reason, the same mistake was not made by the court in Robinson or Thompson, and I would ask Your Honour to not do the same in this court. In remedying this problem, however, Justice Thomas noted that Parliament's intention was to remove the basis of the common law principle that the cause of action against joint tortfeasors is a single, unified cause of action. The effect of this, he said, is to remove the substratum necessary for the operation of the release rule. Justice Thomas went on to quote Justice Gully of Thompson, who stated that case law supporting the unified indivisible rationale for the release rule has been undermined and that there is no longer any rational basis for the rule. Should one attempt to apply the release rule, you must do so on another basis. I ask the court to carefully consider these words, especially when he stated that for the courts to now persist with the rule is to be either pedantic or indifferent to the direction which Parliament, the supreme lawmaker, has chosen to pursue. I would submit that the court should follow Parliament's intention in fixing this major problem and find that the release rule no longer applies in New Zealand.
Isn't it a bit unfair though, where Mercy Hospital here is only vicariously liable for the actions of Dr. Davies, but now you're looking to Mercy to recover as well?
I acknowledge your question, Your Honour. However, I believe that is answered quite thoroughly as a result of my second submission. If I may take you through that, I'll just apply quite briefly. It is simply that Mercy Valley Hospital is joint and severally liable for the damage caused to the McKays. Your question, Your Honour, was, isn't it unfair that Mercy Valley Hospital pay for the damages? Was I referring to the complete damages or part of the damages?
Up to you, we'll make our decision on that front separately.
settlement between Dr. Davies and the Mackays was a release or merely a covenant not to sue. Again, an inherent problem arises before court. The majority in Robinson noted the judgment rule was very inconvenient. If the plaintiff chose to settle with one joint tortfeasor, he could compromise until settlement was secured. But if the plaintiff chose to sue, they could lose their right with no reward or compensation. Therefore, there was no security of right. My learned friend for the appellants has discussed in great detail the material difference in these two approaches and reached a similar conclusion, namely, the difference between losing the right through judgment or simply giving up their right through settlement. The majority of Robinson gave great consideration to the fact that it is illogical to apply the release rule in favour of someone who is severally liable for an obligation. They were of the view that several liability in terms of a release and tort should be determined in the same way as contractual obligations. That is, by taking into account the surrounding circumstances and the express words used in the document, as John noted earlier. Parliament has effectively created a form of liability that would otherwise have not existed. In consideration of the present facts, Dr. Davies approached the couple out of his own fruition in a gesture signifying that he was truly sorry for his mistakes. There is no mention that the hospital compelled him to do so. After a long conversation with the Mackays, the words in the agreement between Dr. Davies and the hospital read as follows. For consideration of $20,000, Dr. Jim Davies is hereby released from any liability in relation to the loss suffered by Catherine and Simon Mackay. There are no express terms stating the Mackays shall not issue proceedings against any other liable party, or that the settlement and compensation between Dr. Davies and the Mackays gave no thought to the possibility of a claim against Mercy Valley Hospital. My learned friend for the appellants has not provided any reasonable basis as to why Mercy Valley Hospital should be cleared of liability for damage when they have not been included in the agreement. There was neither any suggestion that the money paid was full satisfaction for loss. And specifically using the words "and severally" in the heading of section 17, I invite the court to adopt the approach offered by the majority in Thompson, namely that obviously Parliament was intending to widen the net and catch other liable parties. My learned friend for the appellant has been bold enough to state that section 17 does not expressly abrogate the release rule, so it is only fit that I respond with the same boldness in saying that the agreement between Mr. Davies and the Mackays did not expressly include Mercy Valley Hospital. Therefore, Mercy Valley Hospital should remain viable. In conclusion, Honours, whatever route is taken, whether it be the literal or purposive approach, the court should find that the release rule no longer applies in New Zealand. Additionally, it should be held that the appellants were joint and several tortfeasors and that they remain liable. Therefore, the settlement reached between Dr. Davies and the Mackays did not act to release Mercy Valley Hospital from liability.
Thank you, Mr. Daly.
As the court pleases.
All right, we'll retire. Thank you very much.